everyone. Good morning. Welcome to the 2024 Labor Law Update. Today is sponsored by the Workforce Development Board of Ventura County. My name is Anna Manzano, and I'm the Digital Media and Event Strategist here at the California Employers Association. Before we officially get to today's content, I have just a couple of housekeeping details to go over with you. As you probably have noticed, your audio is muted for today's presentation, but there's going to be lots of opportunities to engage during the session. So if you have questions pertaining to the presentation content, you can type them into the Q&A box at any time. If you're on a computer, it's along the bottom with the two bubbles Q&A box. We are lucky to have two presenters today. So while one is delivering the content, one will be helping us manage the Q&A box. And I will be managing the chat box. So if you pop a question in there, I'm just going to kindly ask you to copy it into the Q&A so that we can have our speakers be focused in helping there. Handouts for this training, those were sent out in the reminder email yesterday. And since we had a lot of final signups, I sent it again this morning. If for some reason you need them resent, they didn't end up in your spam folder, just go ahead and drop your email into the chat box, and I'm happy to send those to you once we get going here. And then last but not least, we do have a survey. I promise it's 5 questions. It's less than 2 minutes, but the feedback that you provide to us helps us to continue to develop our suite of resources, trainings like these. We share them with our partners at Ventura so that we can collectively, in turn, help you with, running your departments and your companies with more peace of mind. So, as I mentioned, today's training is sponsored by our partners at Ventura County, and today we have Colleen Smith, Business Solutions Specialist, to share more about the resources available to you.
Good morning, everyone. Thank you so much, Anna. My name is Colleen Smith. I'm a Business Solutions Specialist with the Workforce Development Board of Ventura County. And as you will see on your screen right now, I just wanted to mention our complimentary human resources hotline that we offer. You can call this number anytime, Monday through Friday, 8 to 5, and you will be connected with a live person. You can ask questions like hiring and firing, paid sick leave, information about employee handbooks, harassment prevention, all kinds of any kind of information that you need related to human resources. And you can call as many times as you like, and it is a no-cost service. So it is completely free, no cost to you. And we really encourage you to utilize this very useful service. We also have other services that we can offer as the Business Solutions team. I will put my contact information and our Business Solutions Service Guide in the chat. Please feel free to contact me. We can help with things like training, on-the-job training, incumbent worker training, recruitment services, customized hiring events, as well as job fairs in person and virtual. So if anyone would like to contact me, please feel free to do so, and I will be happy to have a further conversation. And with that, we have a wonderful webinar scheduled for today, a lot of information about the new labor laws. So it should be great. And I will send it back over to CEA. Thank you so much.
All right, awesome. Thank you, Colleen and Cynthia and the entire Ventura County team for gathering everyone here today live and helping us provide this information to you. So as I popped in the chat, while this slide is up, I really recommend taking a screenshot. You also have a copy of this slide in your handout, and then obviously Colleen will be here answering any questions and providing additional ways to contact her team. So all that being said, I have the great privilege of introducing our trainers today. We have Astrid Servin and Eli Nunez, who are two of our amazing HR directors. So again, one will be delivering the content and one will be managing that Q&A box. So we really encourage you to use this time, really get your questions answered in regards to the content today. So I know we have a lot of ground to cover, so it's all yours, Eli.
Thank you, Anna. Thank you, Colleen. And thank you to the Workforce Development Board of Ventura County, too, for partnering with us and allowing us to present this information. Once again, if you have any questions while the presentation goes on, throw them in the Q&A box, or if, we jog something in your mind and you don't think about it till afterwards, give us a call on the hotline. We'd love to discuss it. Speaking of we, if you've been on our webinars before, you know who we are. We're California Employers Association, and we are not attorneys, actually. What we are, what we recommend is if you have any questions of a legal nature, please consult your attorney about them. You'll be able to have attorney-client privilege. They'll be able to look for your best interest and any risk regarding your specific situation. So anything we talk about today should be taken from an educational perspective, right? We're going to talk about some of the changes, things that are going on, but we're not really going to go into legal advice per se. And a little bit more about us, we are California Employers Association. If you're familiar with us, you know that our goal is to provide peace of mind to employers by providing exceptional human resource compliance solutions, training, and recruiting services. So we answer questions, whether it's on the 800 number or sometimes through email. We create documents, employment forms, that sort of thing for members and for sale, as well as creating trainings and delivering them, such as the one you are about to see today. So again, our goal is to provide peace of mind. Let us worry about the HR changes and things like that so we can kind of make it more manageable and more easy, hopefully, for you to digest and implement in your business. So let's get right to it. Some of the things we'll cover today. First thing, of course, is the new mandatory paid sick leave expansion that came into play this year in the state. We'll talk about that and the ways to manage it. New leave of absence, of course, seems like we have a new one every year, and this year's is related to reproductive loss. Cannabis use rights in the workplace. This has been coming for a couple of years. If you've been coming to our webinars, we've been kind of mentioning that this change is coming. So it is implemented this year. We're going to talk about what that means and how to manage that. The Workplace Violence Prevention Plan requirements is a new requirement by OSHA that's going to come into effect mid-year. So we'll talk a little bit about that. Minimum wage and exempt salary increases. If you've been in California for a while, you're used to these. They've been happening year after year, it seems like. So there is a new one for 2024. Agency and regulatory updates. And then, of course, we have some FAQs and more information for you as we go along. If there is one thing that 2024 is has a theme, and that would be the theme would be to update your employee handbook and your policies, right? A lot of things that came into effect. The first one, as I mentioned, the new paid sick leave. And there have been some court cases and some things that have changed how the National Labor Relations Board is viewing policies, handbooks, procedures, that sort of thing. So um, it basically changed the standard of how we should look at policies, procedures, and rules in the workplace. So we'll talk a little bit about that, what that means, as well as new FEHA protection. So again, handbooks, policies, that sort of thing, we like to refer to them as a living document, something you should be looking at on a regular basis, rather than just creating your handbook when you establish your business, putting it on the shelf and never touching it again. These are things that you want to look at every year or throughout the year to make sure you're staying up to date with changes, both from the state and in your workplace. So again, if nothing else, this year's takeaway is it's a year to update your handbook. If you haven't done so already, might be a little bit behind the curve, but now's the time to do it. We're still in January. All right, let's talk about leaves of absence, how they've been expanded, those protections in the state, and how they impact your workplace. And the first one, of course, that pretty much had repercussions across the board was Senate Bill 616, which is the expansion of paid sick leave in the state of California. As you recall, for most businesses, almost all businesses in California, really, several years back, it was mandated that we had to provide our employees with 3 days or 24 hours of paid sick leave. Well, as of January 1st of this year, that has been expanded to 5 days or 40 hours. Now it's 5 days or whichever is more. Keep that in mind. So, for instance, if your workplace operates on a 4 10-hour workday schedule, you're not just going to provide 40 hours, you're going to provide 5 days, which can amount up to 50 hours. So keep that in mind. If you have an alternative work schedule, you have to provide the higher of either 5 days or 40 hours. We could still use the lump sum or the accrual method, which we've been using up until now, to award that paid sick leave. And what really, what really changed as far as the accrual method goes was the cap on how much sick leave an employee can accrue. So it used to be 48 hours, or 6 days, which was 2 times the yearly award, the minimum yearly award. Well, since the yearly award went up, the cap changed as well. Now the cap on sick leave has increased to 80 hours or 10 days. So that is the most someone can accrue if you are using the accrual method. The accrual rate stayed the same. So the minimum accrual rate is still 1 hour of paid sick leave awarded for every 30 hours worked, including overtime hours. So again, that accrual amount did not change. What did change was the cap on how much an employee can accrue per year. Now, something else to keep in mind too is if you use an alternative accrual method, and this is something we typically see in organizations that combine their vacation and paid sick leave into one PTO bucket, then there's an additional requirement for this. Now, used to be that you had to guarantee that the employee would have 24 hours available by their 120th calendar day of employment. With the new expansion, you also have to guarantee that the employee has at least 40 hours available by that 200th calendar day of employment. And again, this mostly affects organizations that have combined their paid sick leave and vacation into one PTO bucket. So if that's the case, you have to make sure that whatever accrual method that you're using or whatever method to award that PTO time is meeting these two requirements. Now, one of the first questions we got when this when this started hitting the news late last year was, if we use a lump sum approach based on the anniversary date, and we previously gave 3 days or 24 hours, can we wait until each employee's anniversary date next year to reset to 5 days or 40 hours? So, for instance, a lot of organizations just that do the lump sum approach basically just use the 1st of January to replenish that amount, but others either use mid-year or the anniversary date. So this affected them. And the answer to that was no. I mean, you can either furnish everyone with the additional 2 days or 16 hours as of January 1st and continue using anniversary dates as a reset going forward, or you can change your policy to reset everyone on January 1st each year instead and provide 5 days or 40 hours. And again, this only applied if you're using a date other than January 1st and you are awarding less than those 5 days or 40 hours before this year. If you're using January 1st as your date and January 1st of this year, you awarded those 5 days or 40 hours, you're in good shape. Disregard the last question. But if you have an anniversary date or an award date somewhere in the middle of the year, make sure that you provided that difference between last year's amount and this year's amount as of January 1st. Next question was, how do I address the new paid sick leave requirements? And this is a pretty general question, right? How do I make sure I'm compliant? What steps do I have to take? And we've broken these down into a few, general easy steps. The first one, of course, is update your paid sick leave policy and the required poster. Now, most of the time, this is included in your general labor law poster that hopefully most of you have hanging up at your workplace in a common area for your employees. Remember, those things have to be updated every year. This year's no exception, so make sure you have the newest paid sick leave poster up. Something else to consider, and the question we got from a lot of our members or other callers was, well, if I'm going to increase paid sick leave, can I reduce people's vacation award? That is totally valid. You can do that. If you're going to do that, make sure you put some thought around what those quantities are going to be and what the messaging is going to be. As you know, it's very easy to give our employees additional benefits, not as easy to take them away or to reduce them, right? Or even to alter them a little bit where it doesn't seem like they're gaining anything. So again, if you are going to alter your vacation accruals, reduce them to make up for those paid sick days or whatever, think about what the messaging is going to be, how you're going to present that to the employees. And again, give them ample time or ample notice before you make those changes so they can process those changes. Next one is updating wage theft notices for hourly employees. And these typically are the forms we see when we hire new employees, right? For those of you that want the official name, it's the State Form 2810.5. And that's the form that gives employees what their hourly rate's going to be for non-exempt employees, tells them what their paid sick leave accrual is, gives them workers' comp information, tells them what the paydays are, all those things. Well, since the paid sick leave amounts changed, that form has changed as well. So, if you are changing the amount of paid sick leave, we have to give our employers some kind of documentation showing them that that has changed. Some people said that, just you could do a separate form that shows them the change, but this 2810.5 form has the information on there already. It's just as easy to pass that out to your employees to make sure that they know. Again, make sure your wage statements are reflecting the updated paid sick leave amounts, especially if you're using the lump sum method. Make sure it's showing the correct amount at the beginning of the year. And of course, take a look at local sick leave ordinances. This change basically caught up California to a lot of the municipalities that had higher awards or more protections, but there are still different protections out there in different cities and counties. So, you know, not sure if Ventura is one of them. You may be in an area that does have additional benefits or additional requirements for paid sick leave, but this really affects those with remote employees that work in other areas, right? So for instance, if you have a remote employee that works, say, in Northern California, in the Bay Area, in San Francisco, or somewhere in Southern California, San Diego, perhaps, there could be different requirements for paid sick leave, whether it's for the amount or the accrual or the carryover, that sort of thing. So make sure that you are um, accurately um, awarding and providing those protections to employees. All right. And it looks like we had a question pop on in the chat here. Let's see. If you are on a 980 schedule, so again, this kind of goes on a on the alternative work schedule. Again, you want to make sure that you award whichever is more out of what is it? 5 days or 40 hours. So if you are on a 980 schedule, Um, and I'll let Astrid maybe correct me if I'm wrong on this one in the Q&A box or in the chat. You may want to take the average of those days and award whatever is the most between 5 days or 40
Right.
hours.
Yeah, Eli, that's correct. So it's either or. So it's whatever is more beneficial to the employee. So if you are on an alternative work week, it will be higher than 40 hours.
Right, right. So yes, so it'll be a higher award than 40 hours so that it averages out to whatever is the higher out of the two. Thank you, Astrid.
And the other,
Next,
just real quick before you move on to that one, the other question was on part-time and full-time employees, whether it's
mm,
for part-time and too, and the ordinance specifically does state that it is for part-time. I guess someone's saying the poster doesn't explicitly say that. I don't know if I read through the whole new poster,
right,
but it does definitely include part-time employees and full-time employees, and even
right.
temporary employees if they work for you for a certain amount of time.
Absolutely. Yep. Those protections apply to everybody. And again, you're awarding them the most or whatever is more out of 5 days or 40 hours. So you could have a part-time employee in there that's got quite a big award. So, take a look at whether you're doing the lump sum or the accrual method. And honestly, there may be something that is more beneficial to you as a business than the other. So it's a good time to take a look at it. All right. Next protected leave or change to protected leaves is SB 848, which is a reproductive loss bereavement leave. Now, last year we had bereavement leave that was made mandatory in the state of California. Basically, if you have 5 or more employees, you have to provide 5 days of bereavement leave unpaid at least. So this has been expanded this year to include reproductive loss events. Now, the state did give us a little bit of leeway on this. It did say that you can mandate that the employee be employed with you for 30 days or more before this protection applies to them. And you can limit it to 20 days in the 12-month period for this reproductive loss event. Now you maybe ask yourself, well, what's a reproductive loss event or what is defined as that? And the state defines a reproductive loss event as a failed adoption, failed surrogacy, miscarriage, stillbirth, or unsuccessful assisted reproduction. Now, one big difference between this and regular bereavement leave, for bereavement leave, you can ask or require your employees to bring you in some kind of documentation, whether it's, a certificate, a form from, a funeral home, that sort of thing. We cannot request certifying documentation for a reproductive loss bereavement leave. We are taking our employees' word for this. So if an employee tells you they have to take reproductive loss leave, those 5 days, make sure that we are not requesting documentation, paperwork, note from doctor, anything like that for this leave. A little bit more about this. Now, it must be used within 3 months of the event, with the exception, though, that if the employee takes another protected leave first, whether it's CFRA or FMLA or something, then that bereavement leave can be taken after the leave. So in other words, if somebody takes a CFRA right after that reproductive loss event or within those 3 months, it basically freezes that 3-month clock and they can, and it doesn't start up again until after they return from that leave. Now, the time does not have to be taken consecutively. In other words, they don't have to take those 5 days off in a row. They could scatter them out as they need them. And the leave is unpaid as well, but the employer can use accrued paid sick leave or accrued vacation time or PTO, whatever they have, they can use that to cover those days. And again, as I mentioned earlier, this is the year to update your handbook, your policies, that sort of thing. So if you have a bereavement policy, whether it's in your handbook or a separate standalone document, make sure that you are updating it to revise these reproductive bereavement leave protections. All right, some other protections for employees, and this is one that, again, caused a bit of a shakeup. Assembly Bill 2188, cannabis use rights. So what this Assembly Bill did was it effectively created a new FEHA protected class for cannabis users. Basically, what this does is it tells employers that we cannot discriminate or take adverse action against any employees or applicants that use cannabis products, marijuana, anything like that, off the job and away from the workplace. So when this first came out, we had a lot of panic calls. Oh my God, does that mean that, my employees can use cannabis at work or show up to work high or what have you? No, that is not the case. Keep in mind it's still our responsibility to provide a safe workplace. So Assembly Bill 2188 does not permit an employee to be in possession or be impaired by cannabis or cannabis products while they are on the job. And of course, there are some certain jobs that are safety sensitive, that you really, don't want people being under any kind of effects or under any kind of narcotics or that sort of thing. So the state did give an exception to these protections for building construction trades or any position where testing is required by state or federal law. So again, if you have any DOT drivers that have to be, certified or they have to be tested by federal law, this protection does not apply to them. This is only for um, any other industries, any other employer. So if you're not sure if this protection applies to you and your business, give us a call. We could discuss, what the facts of your business and that sort of thing, and determine whether this protection applies to you or not. One big effect that this bill did have though was in the way we perform drug screening or drug testing. Traditionally, drug tests, whether it's pre-employment, reasonable suspicion, post-accident, whatever it is, we've used a urine test, right? It's quick, it's easy, it's cheap, that sort of thing. Well, this test is actually not effective as far as testing for cannabis because what it does is it detects the non-psychoactive components. In other words, it detects the chemicals, if you will, in cannabis that don't have any effect on your, you know, basically that don't make you high, for lack of a better word, right? So what this means is that in order to continue testing for cannabis or marijuana, if that's what you choose to do, then you have to make sure that the person you work with, the doctor's office or the background check company or the drug screen company is using a test that detects psychoactive chemicals or psychoactive components of cannabis. In most cases, what we've heard and what our partner OcuScreen has told us, who's basically been at the forefront of this, is that saliva testing, a swab of saliva is so far the one compliant way of testing for psychoactive components. So again, a couple decisions to make. One is, are you going to continue testing for cannabis? Whether it's pre-employment, post, reasonable suspicion, post-accident, whatever it is. And two, if you are, who's going to do the testing for you? We don't recommend you do in-house testing usually, unless it's something that you're very experienced with or you have someone that's been approved to do it. But if you do have an outside resource that does the testing for you, whether it's a local clinic or a medical organization or a background check company, make sure you're partnering with them. Make sure you're having this conversation with them to know that they are compliant with the new testing requirements. Now, right along with that other protection, we have Senate Bill 700, which provides protections to cannabis for candidates or an employee's cannabis history. So what this means is that we as employers cannot request information from an applicant regarding prior use of cannabis. So we can't ask, in our application or interview, have you ever smoked marijuana before, used marijuana, used cannabis, whatever it is. Now we can consider prior use only if we obtain this information with a criminal history report and you follow all requirements under the Fair Chance Act. So in other words, if you do background checks as a part of your employment process, of your new hire process or job offer process, and it turns out that someone's got a conviction for possession or being under the influence of cannabis, you have to follow all the requirements of the Fair Chance Act. In other words, you have to, you know, come up to a determination about whether that conviction is directly related to the job they're going to be performing. If it's not, we have to disregard it. If it is, then you can take some other steps in order to disqualify them from that position. So what do we do with all this information? How do we manage these new cannabis protection requirements? Well, first thing you're going to do is, if you've tested employees for cannabis in the past, whether it's new hires or whether, reasonable suspicion or whatever, sit down, determine if you're going to continue testing for it. And if you are, make sure that you're using the compliant testing method for it. Of course, our policies have to be updated with the language regarding, these protections, that sort of thing. And most importantly, we need to train our managers, supervisors, especially our frontline managers on these new protections. A lot of times we see when companies get in trouble, it's not as much because the owners made a wrong decision or upper management, the directors made a wrong decision. Sometimes it comes down to your line level managers or supervisors not being aware of changes or not being aware of the right direction to go with things. So make sure that we're trickling this information down, letting our managers know what they need to know, what these protections mean for them, and what they can and cannot do. All right, next protection for employees, Senate Bill 699, and this is regarding non-compete agreements. Now, if you've kind of been paying attention the last couple of years, non-competes have kind of been ping-pong back and forth, where they're going to be allowed, where they're going to not be allowed in California, that sort of thing. And most recently it landed on, we're going to prohibit non-compete agreements under the Business and Professions Code in California. Well, Senate Bill 699 expands this protection. And this is a controversial bill because it extended these protections beyond the California state borders. So with this, initially it used to be that California employers cannot enforce non-compete agreements on California employees. Well, Senate Bill 699 said, you know what, no matter where that non-compete was signed, whether it was signed in California, whether it was signed in New York, or, whatever state of the union was signed in, it is not enforceable in California. So as you know, I mean, this, as you can imagine, this made California really unpopular with other states, and especially with large companies outside of the state, because basically that means that their non-competes are not enforceable in California. So that means California industry, California employers can hire somebody away from their out-of-state direct competitor. Again, very controversial. We'll see where this, if it still stands, but as of now, this is an action. Now, something else it did was it created a right of action for violations. In other words, if there was a violation or it affected a candidate or they were not employed because of non-compete, they can obviously get compensated for attorney's fees, current and this applies to current and former employees. So again, this provided employees some teeth to go after former employers if their non-competes affected them in some way. So our advice for this, of course, take a look at your employment agreements, especially if you've used non-competes in the past, or if some of the language sounds like a non-compete. Consult your legal counsel just to make sure that your employment agreements are compliant with these new protections. And related to this, of course, is Assembly Bill 1076, which basically mandates that we have to send void notices regarding non-competes. So what this means is that if you have any current or former employees who were employed after January 1st, 2022, so in the last 2 years, and entered into a non-compete clause or agreement, unless it was permitted, of course, by the Business and Professions Code, then we have to send them a notice that that non-compete is void. Again, whether it's a current employee, former employee, if they were hired after January 1st, 2022, we have to send them that notice. And there is a deadline for this. Happy Valentine's Day. We have to get this notice out to them before February 14th of this year. Now, this notice should be sent to their last known address and last known email address. So again, if it's a former employee, we want to send that information to whatever information we have on file. We always recommend, of course, if you're sending anything by mail to what employees, former employees, whatever it is, we recommend having some kind of way to prove that it was delivered, whether it's one of the commercial carriers or whether it's registered mail or whatever. Make sure that you have proof that it was sent and delivered just in case it comes back. I mean, it's, costs you a few dollars now, but it could save you some money down the line. And of course, any violations of this, whether you didn't send them or whatever it is, you could be subject to a claim of unfair competition. So be very, diligent about sending this out. Audit your rosters, audit your employees. If you've used non-competes in the past, if anybody falls within this time frame, make sure you're sending these notices out. All right, next one for you, and it sounds like I'm just the bearer of bad news here. Senate Bill 497, which is a retaliation presumption. And what this one, what Senate Bill 497 does is it states that if any adverse action is taken against an employee within 90 days of them, basically filing any kind of claim under the labor code, whether it's a wage claim or complaint about unequal pay or anything, the state is going to assume that it was unlawful retaliation. Now, whatever the adverse action was, if you suspend them, if you lay them off, if you give them a write-up, whatever it is, the state will assume that it was retaliation based on them making that wage claim or complaint against equal pay. So what this basically does is it puts the burden on the employer to prove that that adverse action, whatever it was not retaliation. So basically, it puts you up to bat with 2 strikes against you already, if you will. You have to prove that you were not retaliating against this employee for the wage claim or for the complaint. So again, as you know, if you have to deal with any of these state agencies, having to prove that you're in the right or having to prove that you did not do any wrong is not a position you want to be in. So our advice, be very careful if you have any employees that have filed any kind of wage claims or complaints. Be very careful if you have to take adverse action against them. And sometimes it's easier to set these expectations from the beginning, right? If you're consistent with your employee actions, with your corrective actions, with your write-ups, that sort of thing, if you've been consistent from the very beginning and been diligent about documenting things across the board, that gives you a little bit more, puts you in a little bit better position to have that rebuttable presumption. If you're kind of spotty with your documentation or with your write-ups or the way you enforce your policies, you could find yourself in an uncomfortable position. Okay, let's talk about some agency and regulatory updates for you. I alluded a little bit to the Fair Chance Act before when we were talking about cannabis convictions, and this is the one of, you may be familiar with it and may not be surprised that this started in the Bay Area, right? These protections for the Fair Chance Act started in San Francisco, actually, and basically initially prohibited any employer with 5 or more from asking about criminal history during the application or interview process. So this is what caused us to go back to our job applications and remove that question that said, have you ever been convicted of a felony? Hopefully you removed it from your application. There's been a law for a couple of years. So there's a reminder to go back and review your application process to make sure that that's not there, as well as not being able to ask about it during the interview process. Now we can do a background check or ask about it after a conditional job offer has been made. And a lot of times that's written right into the offer letter or the offer documents that said, we're offering you this position contingent on successfully completing a background check and a drug screen or what have you, right? But again, that's after a conditional job offer has been made, not during the interview or application process. Now, the expansion also means that we can only deny the job to the candidate if the conviction has a direct and adverse relationship to duties. So what's that mean? It means that, if any kind of felony conviction, any kind of conviction pops up, it's not an automatic disqualification. Now we have to go back and analyze what the conviction was and whether it is directly related to the job at hand. So the generic example I always use is if I own a sandwich shop and I'm trying to hire somebody to be a sandwich maker, I offer them a job, I do a background check, and it turns out they have a couple DUIs on their record. Does this mean I could deny them the job because they have a couple DUI convictions? In this case, it wouldn't, because having, vehicle infraction or DUIs is in no way related to making sandwiches. Now, if I'm hiring a delivery driver, it's a different story because they're going to be driving for me, and those convictions show that there could be some kind of issue there or have a direct and adverse relationship to their duties. So again, be very careful with that. And what we do as far as those background checks, how they affect our candidates. Now, these protections, the expansion, it used to be just for outside candidates when we had new applicants, new, interviewees, whatever it is. Well, these protections have expanded to internal candidates, to our existing employees. So in other words, if you have an opening internally and you have an employee that applies for it, whether it's a promotion or a transfer, whatever it is, then they also have those same protections regarding, any kind of convictions or criminal acts or that sort of thing. And this even applies to an employee that indicates a desire to be considered for a different position. So even if they're just inquiring for it, we can't just say, "Oh, well, no, I heard you have a criminal conviction, so you probably shouldn't apply for it." That would be a violation. Again, expansion is going further. They protect employees that are being evaluated due to any kind of organizational changes. So if your company is bought or sold and you're going back and rehiring employees or reevaluating them, or having them go through the application process, these protections are going to apply to them. Same if there's a management change, policies, practices, that sort of thing. These protections are applicable at that point. So as an example, we have this situation that occurs sometimes. My manager was having a casual conversation with our employee, Betty, who disclosed that she has a drug conviction. My manager now does not want to consider her for promotion. Is this okay? As you can imagine, based on what I just said, the answer is no. The manager must first consider her without regard to criminal history, because employees up for promotion are protected. Again, these protections have extended to internal employees. So the law applies even if the disclosure is unprompted and voluntary. So even if the employee volunteered this information, we cannot consider it until, after the position has been offered, which I know sounds kind of counterproductive, right? Sounds like, we're spinning our wheels at that point. But again, that is the law. We cannot consider that information, whether it was given to us voluntarily, whether it came up in conversation, whether we received it anonymously, until that person gets to that point where the job has been offered and we are going to perform that background check. So a little frustrating, I know, because it seems like it could feel like a waste of time. But again, these protections allow everybody to get a fair shot at positions, promotions, and that sort of thing. And some other things to consider, of course, is that these protections or these kind of ways to disqualify people are not a one size fits all, right? It's not oh hey, a conviction showed up, so we're going to disqualify this person. Uh, Basically, what this means is we now have to do individualized assessment for each of these situations. So if you do a background check on somebody and certain things come up, we may have to do assessments to see what they mean and whether they can challenge those convictions, right? So again, what this means is that the applicant can provide us with evidence that challenges that conviction or shows rehabilitation or other mitigating circumstances to explain the conviction or explain the situation. And even though we as employers cannot require this information, we have to consider it if the applicant voluntarily presents us with it. So some examples of what these documents could look like could be employment history or records, vocational training or rehabilitation certificates. If someone has a drug conviction perhaps, but they present us with a rehabilitation certificate afterwards, we have to consider that before disqualifying them. Letters of reference, documentation of traumas, such as police reports that could explain the situation or why the conviction took place, as well as documentation of disabilities, both mental and physical. So again, it's not just a case of, something pops up in the background check and we're disqualifying someone automatically. Now we have to do an individualized assessment for these situations to see if there's any mitigating circumstances that could explain them. We do have fact sheets for our members that kind of helps to explain this new process. And of course, the state's probably going to put out some forms, or has put out some forms to help us go through this process as well. All right, next topic we have relates to a National Labor Relations Act and the National Labor Relations Board. Now, a lot of times when we talk about National Labor Relations Board, most people assume that this is just related to unions, right? And that's usually when we hear about them, whenever there's a union election or some kind of labor organization movement or something. But the thing about that is the NLRA basically provides protections to all employees, whether there's union or not. that protection applies to all. And specifically what we're talking about here is Section 7. And what Section 7 of the NLRA does is it gives employees the right to communicate about wages, hours, and terms and conditions of employment. So if you may recall, back in the day, we used to be able to tell our employees, or maybe we didn't used to be able to, but we did tell our employees, hey, I don't want you talking to your coworkers about how much you make or about your raise or what have you, right? I don't want you talking about it because it's going to cause problems or whatever. Well, Section 7 prohibits us from denying employees the chance to talk about that sort of thing, about wages, hours, terms and conditions of employment, that sort of thing. You're saying, well, thanks for the history lesson. What does this mean to us now? Well, thing about the National Labor Relations Board is these are not elected officials. These officials are appointed by whatever president is in power. And as you can imagine, the makeup of the board shifts based on which party is there, whether they're pro-labor, pro-employer, whatever it is. Currently, we have a very pro-labor National Labor Relations Board. And the way they interpret some cases basically has an effect on employers across the land. So what's happened recently? Well, there's been some cases come through that have caused a ripple effect out as to how things are interpreted in policies and employee handbooks. And what this means is that any workplace rule that's challenged will be presumed unlawful if it has, and I quote, this is directly from the words, a reasonable tendency to chill employees' exercise of their rights. So in other words, if a policy or part of the handbook is seen to be quieting employees or preventing them from talking about the situations or sharing this information or what have you, it is presumed to be unlawful or illegal. Now, the employer can rebut that presumption, say that, that we have to have this rule in place to protect my business because, it protects substantial business interests or whatever. But they have to be very, very specific. And if you have any more information or a little bit more background on this, we did have a great blog article that's open to everybody that's called that's called Review Your Policies with a Magnifying Glass. And specifically the case that came through that kind of accelerated this change was, I believe, the Stericycle case. So this article there really goes a little bit more in depth into it and talks about what it means. Now, I know it's a little abstract, so we do have an example of how this applies to you. So for instance, if you have a policy that says, discuss work matters only with other employees who have specific business reason to know or have access to such information, that is more likely than not going to be presumed to be unlawful. Reason for that is it's very generally phrased, right? Discuss work matters only. I mean, again, very generic. Basically says, unless you're talking specifically about work, don't talk to your coworkers. Now, what's more likely permitted is do not disclose confidential financial data or other non-public proprietary company information. Do not share confidential information regarding business partners, vendors, or customers. Now, I would assume that whoever wrote that top policy, the unlawful one, meant to basically, say what the permitted one said, right? We don't want you talking about confidential information, proprietary information, that sort of thing. Well, the way the NLRB is looking at things now, we want to make sure that we're very specific when we're prohibiting any kind of communication between our employees. So what's this mean? What do I have to do to be compliant? Well, few things to do based on what I just talked to. I mean, we want to make sure we take a look at our job applications and interview questions, right? Make sure that we're compliant with the criminal history protections. And again, same thing as I mentioned before, make sure this information is trickling down or down to your line level managers, right? If you have supervisors or foremen that help with the interview process, make sure that you're training them, providing them this information, and really reviewing what their interview process is to make sure that they're not asking any questions that could cross the line, be illegal, or possibly be interpreted as being illegal. Sometimes it's the interpretation, sometimes the perception. So make sure that you are providing training and guidance on that thing, on those things. Let's train our managers and those involved in the hiring process on prohibited criminal history questions, and audit and update our employee handbooks and policies to meet the new National Labor Relations Board standard. Again, this is the year. Take a look at your handbook. If a lot of the rules are somewhat generic or somewhat, far-reaching, make sure that make sure that we're looking to take a look to see, if we have to be more specific to it, or there's some parts that have to be changed, or we have to any disclaimers or anything like that to make sure that we are not raising any eyebrows over at the NLRB. All right, with that brings us to right about the halfway point, a little beyond it. So I will see with Astrid, see if we have any outstanding questions over there.
Yeah, somebody asked about can you have a specific policy on disclosing terms of separation? That's a good question. So, in regards to that NLRA, could you have something that prevents them from discussing their terms of separation?
I don't think, and again, I'm not a lawyer on this one. I don't think you could have something discussing specific terms of separation in general. Now, if you're concerned about it, that's where a severance agreement would come into play. Where a legal counsel would be able to craft something specifically for that person for that situation. I don't know if you would be able to have a blanket policy that would cover all employees. I think that may raise a few eyebrows over there.
I'd agree with you. I think if you had a release in exchange for that, that prevented them, but absent that, I think it may be a
Yeah.
difficult situation to be in.
Again, remember that phrase, if it seemed to, and the quote unquote, chill the employee's rights to or the employee's ability to exercise their rights. And that rule kind of feels like, even though it's a terminated employee, the termination is still part of their employment. So
Maybe don't put that in writing on a policy.
Correct.
Yeah.
Good idea. All right. I believe it's all. Any other questions out there? Yep.
Let me see. Okay, they just said thank you.
Yep.
No, I think
All right.
I think you covered it very well. Thank you, Eli. Give you a
got it.
break.
All
And I'll
yours.
take over from here to do the, again, don't shoot the messenger, as Eli said. We're on your side, employer, but there is some wage and hour updates because as my boss likes to say, we don't work for free. And so there are some updates to the wage and hour in California, never fails. So the minimum wage for the state of California currently is $16 an hour. So make sure your minimum wage workers are at least making that $16 an hour. And sometimes when there's an increase to the minimum wage and the lower income employees are now earning 16, other employees say, well, what about me? I was already close to that, and now they're kind of catching up to me. So there is no requirement, of course, to increase anyone else's wage if they're an hourly employee, but that is something to consider budget-wise, morale-wise for your company. What happens when there's a state minimum wage increase is then there is also an increase to our exempt or salaried employees. So because we are at $16 an hour, that typically is double the state minimum wage to get your yearly exempt salary. So if you have exempt employees, make sure you're paying them at least the $66,560, which is quite a bit of jump from last year when we were at 64 and change. So some employers have found that was too big of a hike to take, and they couldn't keep exempt employees at that 66,560. And also consider next year when there's probably likely to be another increase. So another option employers can think of is maybe dropping them to hourly. And you would just take that, whatever you were at, 64,000, for example, from last year, and divide that over by 2080, get an hourly base rate and pay that amount. But just remember, transitioning an exempt employee to non-exempt, there's quite a few things to consider. So we do have a bit.ly here, a link to some free tips for employers to use when transitioning that employee from an exempt salary, which they're used to not tracking time, they're used to not having anything regarding their schedule, to now an hourly position. So take that into consideration. A lot of times we get asked whether or not we can just use the salary as the reason why they're exempt, and we can't. In California, you have to meet two criteria in order to have an employee be exempt. One of them is the salary, so you have to pay them at least the $66,560, and the other is the job duties. Both need to be met in California in order to qualify for that exemption. And the job duties test, if you're a member, we have worksheets for you that you can use to go over whether or not your employee meets that definition of exempt. Because in California, workers are considered by default hourly employees unless they meet that criteria to be exempt. So ensure that you've gone through that. The hotline's a great resource for you to call in and say, look, this is the job duties of my employee. I feel like they meet that definition. We can't analyze it for you, but we can share the information and have you analyze whether or not you think that meets the definition. So along the same line, minimum wage, you have to consider the minimum wage for the state, but then also the local ordinances, because there are a lot of state cities and counties, not necessarily in Ventura, but there are some cities and counties that do require a higher minimum wage. And if your employee is crossing the line into that area or is working from home from a municipality that requires a higher minimum wage, then you are subject to the minimum wage where your employee is physically working. So whether that be their home residence or if they're driving and commuting into the Bay Area or San Diego, as Eli mentioned, you have to consider not just the paid sick leave in that area, but also the minimum wage in that area. So if you are in need of a worksheet, you can follow this link here, type that out into your browser, and you can see all the minimum wage by location to be certain that where your employee lives or works isn't a higher minimum wage area. So again, sticking with wage and hour, this area is personal vehicle usage. We want to make sure you're aware that in 2024, the minimum wage or the minimum rate for mileage with the IRS has gone up to 67 cents a mile. It was 65.5 last year. And the IRS mileage rate is what we pay our employees, whether they be hourly or exempt, to drive on company business. So if they're using their personal vehicle for work, whether that be because they're doing a Starbucks run for the whole company and you've asked them to do that Starbucks run, or they are buying supplies, they're picking somebody up from the airport, they're going by the post office to mail that check for that employee, all that is time they're using, not only the time, which we'll talk about in a minute, but also the mileage. So if they're using their personal vehicle for work, we are responsible for paying them. Now, you don't have to pay the 67 cents a mile that the IRS has dictated, but the labor commissioner has ruled that the 67 or opinionated that the 67 cents a mile from the IRS is a reasonable reimbursed amount for an employee. So that covers wear and tear, it covers gas, but you employer can say, look, I'm only going to pay 40 cents a mile because I give them a gas card, or I'm only going to pay 50 cents a mile because I do other things to upkeep their vehicle. So if the burden will be on you, the employer, if you do decide to go with the lower rate, to decide that the mileage you're reimbursing your employee is sufficient. You can always go above the mileage IRS rate as well. So remember, you do have to pay your hourly employees for the time they spent commuting during that time as well. This is work time. So if you are having them go to the post office or pick somebody up from work at the airport, that is company time if they're hourly. If they're exempt, of course, it's a different story, but you're paying both mileage and drive time for that time they're commuting, because that is outside their normal commute time. So we have the normal commute to work, and then we have time that they spent using their vehicle throughout the day. They got to be paid for that. And you can pay a lower rate for any travel time. So if you have drivers, for example, maybe a plumber that goes in and does work, but then they're also spending time commuting to the next visit, the next location, that drive time can be paid at a lower rate. It can go as low as minimum wage in the area they're working. So if they're in Santa Monica, for example, you're paying the minimum wage in Santa Monica. If they're just in a regular city that doesn't have a different minimum wage, you can pay the minimum wage for the state. Just remember, when you're doing that, it creates an accounting maybe nightmare for your accounting department, where they're now tracking different rates of pay for the different hours in the day. So just kind of watch out for that. Some employers are like, you know what, I'm just going to pay them a flat rate for the entire day, and I won't mind when they travel and they're driving on time. So just remember that for your hourly employees, we're paying both mileage and drive time. And for your exempt employees, you're always paying for mileage as well. Okay, moving on to the physician and computer professionals. So this is going to impact some employers in Ventura County if you're in this area, or you may be hiring a computer software professional to do something special for your company. So just know, if you want these employees to be exempt from overtime, their minimum wage has also increased. So physicians and surgeons, they've gone up to $101.22 an hour. Computer software professionals are those very high level computer computer professionals, such as people who are coding, computer professionals who are computer engineers. This is high level. This is not your IT desk, nothing like that. But this is someone you've hired in a very high level computer software. Their minimum hourly rate, monthly and annual, has gone up, as you can see here. And this is the minimum you have to pay if you want to be hire them in an exempt capacity and not pay overtime. Okay. Moving on to remote work expense reimbursements. This one, there's a lot of gray area still on this, but there are some things that we know about. So there's a labor code that says you have to reimburse employees for the cost it takes them to conduct business for you. So if you require any remote or hybrid worker, or you encourage it, you have to cover at least those basic work from home costs. So you're going to cover at least internet, office equipment, anytime they use their personal mobile phone for work use. These are, this has been decided already. The labor code says you have to pay for this if you're requiring them to work from home, if you're encouraging them, there really isn't a spot at the office, so you're kind of encouraging them to stay home, then this is automatically a reimbursement you have to provide. And you have to determine what a reasonable percentage of the total cost that represents work-related usage. So you might say, look, I'm not going to pay your entire phone bill because that's $100 in a month. You're not using your entire phone plan for work, but you're using a percentage. So look and see what a reasonable percentage would be and pay that. And you can request that bill from the employee and reimburse them monthly for a certain amount. It could be different for employees who are working 100% remote versus those who are hybrid. Remember, if you're obligating your employees to use their cell phone to clock in, for example, or to take a picture and send it to you, those are the costs that the employer has to cover, even if it's just a small percentage. It does need to be reasonable, and it does need to be paid out again to that employee under an expense reimbursement. Some employers have opted to do a monthly stipend instead that sufficiently covers this cost. So they'll say, look, this is your work from home stipend. It's a dollar amount flat that we think is going to cover everything. And that is something you can consider and do. However, just know that if you do that, it is a taxable line item for your employees. So you're taxing the stipend only. So the other things to consider here also, whether or not you have to do things like other utilities, like it's really cold right now and I'm turning up my heater, so you have to cover a portion of my heating bill. Those are things that are still they're actually in the courts right now. There's some gray area around it. So proceed with caution. The other gray area is, look, I don't require you to work from home. You're voluntarily choosing to work from home. So do I have to cover costs? And again, that's in the courts right now. Proceed with caution in those instances because we are in a California employee-friendly state. Although those haven't been decided, they will be soon. Probably Amazon has a few cases out there, and those cases should be probably decided in the spring. And a lot of times California will say, we're going to retro back. So proceed with caution when allowing this stuff. Some employers are saying, look, there's a ream of paper you can come pick up. You can please utilize that ream of paper when you come into the office. Do your printing here versus at home if you don't want to provide a printer. So there are other options, but make that clear in a policy. That's the biggest thing, is having a policy in place for remote worker, or anytime there's any kind of expense to the employee, that they have to get authorization before an expense is made. Make sure that's in writing so that everybody is clear about this. So some to-dos here: check your county and city minimum wage laws. Expect, again, just like with the sick leave, there's also minimum wage poster updates, and execute a remote worker agreement. Like I was mentioning before, you should have some sort of policy that says, here are your hours, remote worker. You're expected to be at work from 8 to 5. You're expected to be presentable. Should we have a Zoom call, don't be in pajamas. The dress code applies. All the handbook policies apply, whether they be harassment, discrimination, or dress code or schedule. All those policies, as far as when to take your meal period by the 5th hour, all that if you're an hourly employee, all those laws and policies that we have in our handbook apply even when working remote. And then have some sort of checkout of equipment available that you've actually logged, we've checked out a laptop, we've checked out a printer, a cell phone, because when that employee terminates, you have nothing to prove that you've checked these items out. It's going to be very difficult. It's going to be difficult for you anyway, but even more difficult, and you don't have some sort of property agreement that is signed of what we've checked out to the employee. So always have some of those things, those work parameters, including reimbursement, getting permission before an expense is made. All that should be in a policy. If you're a CEA member, we have a remote worker agreement template that you are free to use, and it already has that property agreement attached to that remote worker agreement. Sometimes we just take the property agreement and that's all we need. So ensure that you have that for your employees. Pay compensable time and reimburse employees for all business-related travel beyond their normal commute. Remember, we have a normal commute. We don't have to pay for that, but anything above and beyond that normal commute does need to be paid, at least at minimum wage. And then remember to budget for those minimum wage and salary increases. If you have those municipalities that went up in July, they're likely to go up in July again. I know LA City's going up in July. A lot of these county and cities go up mid-year. So I'll stop there and see if there's any questions, because it sounded like the Q&A went up. Eli?
Yeah, there was a couple, and especially on this work from home, right? This remote work.
Mhm.
One of them was if an employee chooses to work remotely, so in other words, if we're not forcing them, do we still have to pay them for their work-related expenses? And again, that goes back to, if an employee is forced to, I believe the word was suffer any losses or anything for work or for the benefit of the company, then that could be compensable as well. So again, it goes back
That
to
gray
making sure
area.
that work from home agreement, make sure even if it's temporary, make sure that if you're agreeing to it, that you are outlining what is, you know, what is expensable or what they can expense and what they cannot, what they will be compensated for. And then the other one was on if you have a stipend for work from home or if people are working remotely, is that taxable? That was
Yeah,
a
the
big, yeah.
stipend is taxable.
That is a taxable one. Now, if it's just an expense, if they went out and bought, a ream of paper or a printer or whatever, that's an expense. We're not going to tax them for it. But if it is a stipend, that is going to be taxed.
Yeah, good
So,
questions, everybody. And with that voluntary work from home, again, it's something that will be decided soon, but be careful with that. Have those agreements in place so that there's clarity about why are they working from home? Are we allowing, it reminds me of that case with the cell phone. I think Jessica had talked about our colleague, and she had said that there was a case with the cell phone. Well, they have an unlimited cell phone plan. So they're not incurring any cost already. So why do I have to pay a portion of that cell phone bill when they're not incurring any costs? And the courts decided, no, you do have to cover a portion, not all of it, but some of it, even if they have an unlimited plan. And that's similar to what this voluntary work from home, we're allowing it. So if we're allowing it and they're suffering, some sort of expenses due to work,
yeah,
are we going to have to reimburse? And I think that's what the courts are weighing
yeah.
right now.
And the argument that they're saving costs by not commuting has not held water in court so far. So
No,
it,
no.
it could be an expense. Awesome. Thank you, Astrid.
Yeah, thank you, Eli. And stay tuned, everyone. Sign up for our blog because when these cases are decided, we're kind of nerds that way. We like to keep up to date with these court cases, and then we send out a blast, or we'll write a newsletter article about it. So sign up for if you haven't already, go to employers.org. There's a newsletter you can sign up for, and then also we will alert you when there's a new blog, and you can check out our blog at any time. So moving on to from the wage and hour world into the safety world, which is a headache also. And let me just check my clock here. We have some time to cover this. So Senate Bill 553 is the Workplace Violence Prevention Plan. WVPP, we'll have to get used to another acronym here. WVPP is a new requirement to establish and implement and maintain a written workplace violence prevention plan by July 1st. So you have some time, but it's going to go quickly. So we want to make sure that you're aware of this requirement under the Senate bill. This is something Cal OSHA has been in the works for years. They've been trying to figure out how we're going to have this workplace violence prevention plan, and they didn't quite get it. And so this senator up in the Bay Area said, well, due to some unfortunate incidents where there was workplace violence, they went ahead and started drafting this Senate Bill 553, and it passed. So this is going to require employers to train their employees on this violence prevention plan by July 1st. We got to develop it, have it written out. There is no template yet, and then you have to train your employees on this plan and then every year thereafter. So, you know, the sexual harassment training, we are allowed to do that every 2 years, but with this one, it's going to be annually. So it is a big burden. You have to start planning for that now. There are very few exceptions. The exceptions are if you are a 100% teleworking company. So you do not ever come into the office, you're 100% remote, you're exempt from this. If you are a small employer with fewer than 10 employees at any given time, and you do not access the public, and you have a compliant IIPP, which is that Injury Illness Prevention Plan, if you have one of those, then you are exempt if you're a very small employer. And then, of course, our healthcare facilities, Department of Corrections, law enforcement, they have a much more strict plan. They've had that one in place. If you try to Google, in fact, a workplace violence prevention plan template, you're going to get the healthcare one. So don't try to Google that because it doesn't exist yet. And if you do get one, it'll probably be the wrong one. So we're waiting for Cal OSHA to determine what those the template is. We don't know if they're going to have one, but this is what it entails. You can incorporate this plan as part of your IIPP. Remember, the IIPP, the Injury Illness Prevention Plan, is something that is also required. Cal OSHA does have a template for that. It's required of all of our employers, and you can download that template from Cal OSHA's website. So you can incorporate this violence plan as part of that IIPP, because IIPP is all safety stuff. Or you can have it as a standalone document, whichever you prefer. So the inspections is something you're going to do. You're going to do an inspection at the onset of this plan when you first establish the plan. And then after, you're going to also do an inspection after any new incident or hazard. So an inspection can look like, you know, walking your building and ensuring where are our exits? Where do we go? Where could we hide if there's an active shooter? What does the lighting look like in the parking lot? Do we have sufficient lighting? Are our exit doors not blocked? So doing an inspection of any kind of hazard that you may have, potential hazard, and checking off that you've done that inspection. And then if there is an incident, knock on wood, then you would have to do another inspection following that. It also requires you to continue to have a violent incident log, very similar to your OSHA 300 log, where you log all your workers' comp cases. Very similar to that. You're going to have a violent incident log following an investigation, and we'll go through some examples of what you would log under this plan. And then the records of identification, evaluation, and corrections, anything related to this plan has to be kept for 5 years. And then your training roster, your training record has to be maintained every year for 1 year. This Senate bill requires Cal OSHA to propose standards by the year after next, December 31st, 2025, and to adopt them, because that's just the way the rules are for Cal OSHA, the following year. So even though these standards haven't been completely written by Cal OSHA, we have the Senate bill that will that forces us as employers to act on this plan and enforce it now. Cal OSHA is going to be enforcing it even though their standards are not out. And Cal OSHA, we're hoping, comes up with some sort of template, again, like the IIPP or the COVID prevention plan. But as you all remember, when we were in 2020 and COVID, it took a while for them to establish that COVID prevention plan. They just wanted us to do something. And finally, they came up with a template. So we're hoping something comes up soon. Stay tuned again through CEA, because we do like to keep in touch with this stuff. And if there is a template, we will inform employers. And if there isn't one, we will try to do something, partner with our safety partners, and come up with some sort of solution for employers before the deadline. So what are some examples of recordable violent incidents? It could be something like a physical attack. So if you're, for example, employees are fighting on the premises, that could be something that you log under the violent incident log. It could be a threat. I want to punch you in the face. And there isn't a punch in the face, but there's a threat of physical force or use of weapon. That needs to be logged. If there's a sexual assault or unwanted verbal or physical sexual conduct, consider those employee complaints of sexual harassment complaints. If they're founded, if they're substantiated, those would have to be on the incident log. If you have employees going outside, outdoors, an animal attack is also something that could be logged on there. Then we have this other that, again, we're hoping Cal OSHA clarifies and defines as what else can be on there. But again, any kind of threat from a customer, active shooter situations, all those things are the kind of things that we need to log. So prepare for this workplace violence prevention plan by July 1st. Think about who you're going to implement, who is going to be responsible for implementing this plan. Hopefully you have a safety committee already that implements the IIPP. Have those folks start looking at this workplace violence prevention under this Senate bill. Again, we don't have a lot of information of what's required, but do the minimum of what we do have. What we do know is for you to do that inspection, train your employees on these cases of workplace violence, and then have the log ready. And we do have a template for that log on our website. So log again into employers.org, and you can find that template for the workplace violence. And remember to be prepared to deliver training, have some sort of system in place so that by July 1st, you've trained all your employees, and then annually thereafter. Prepare for inspection, again, your own inspection as an employer, and who's going to retain those records, how are we going to keep them, where are we going to go with this stuff. So let me know if there's any questions, Eli, otherwise I will keep going. Are we good to continue? All right, let's go. So we're going to have just one COVID slide, which I'm very excited about to be featuring only one, because our labor law updates has included quite a few of these slides with the very scary coronavirus bug there. And now it's less scary and it is only one slide. So and it's already changed because Cal OSHA has changed their requirements as of 2 weeks ago, which is, I think, a little better for employers, but depends on who you talk to. But first, before we go through the quarantine change, let's talk about Cal OSHA's permanent COVID standard, which is still in effect through February 3rd of 2025. So this is what we're continuing to do as employers. We're still required to have a COVID prevention plan. Cal OSHA provided us with that template. Make sure that you're still using that, that you're, you're working with that COVID prevention plan. And the required exclusion after testing positive, that's what's changed. So the very recent, as of 2 weeks ago, the California Department of Health has changed their quarantine exclusions for employees who test positive. So if employees test positive and they have no symptoms, they can remain at work without any kind of exclusion, as so long as they're wearing a mask for 10 days. And if they test positive and do have symptoms, then they need to remain out for at least 24 hours, ensure they have no fever, and if their symptoms are improving, they can return to work now after 24 hours, so long as they wear a mask for 10 days. That's the new requirement, which again makes some people nervous. And so you can have, as an employer, a more strict policy than that. But the California Department of Health, when there's a change, Cal OSHA aligns with that change. So they have updated their Q&A as well at Cal OSHA's website. And so that is the new testing exclusion periods, which is not very much. And you do still have a requirement, however, to inform those close contacts. So you do still have that requirement. If there was a close contact exposure to that employee who tested positive, you do need to notify them. What's no longer required is the mass employee notification of a positive case. We used to have to tell the entire building, not just the close contacts, but everyone that there was a positive case in the building. And then we also had to report it to the workers' comp carrier, and we no longer have to do that. So those two requirements are no longer there, but still need to notify the close contact and ensure that you change your COVID prevention plan, all your policies, inform your supervisors of the new exclusion, discuss whether you're going to follow that or if you're going to be a little more strict with that new case. Okay. So let's move on to some industry specific updates here. It may affect you more as a consumer than it is as an employer, depending on your industry, but it is still worthwhile to note that this has passed. This is AB 1228. It was passed as AB 257 last year under the FAST Act, but the FAST Act was repealed and replaced under new terms because there was kind of crazy. They were going to pay fast food employees $22 an hour last year. And so that quickly got revised and renegotiated, and we're still looking at $20 of minimum wage as of April 1st for our fast food workers of large chains over 60 restaurants nationally. So your big Starbucks, your McDonald's, all those are going to be enforced as $20 an hour, which means if you are an employer not in the fast food industry, but you're paying $16 an hour, you're now competing with these establishments that are paying $20 an hour. So it kind of creates some competition out there for different minimum wage industries. So the other thing that is troublesome for employers, even if they're not in the fast food industry, is this Fast Food Council that's been established under the Department of Industrial Relations. It's a very small committee, a very small council who have been tasked with creating and recommending working conditions for the fast food industry and setting minimum wage for them. This is unprecedented. We've never had some sort of council that speaks to this industry, and they're going to be doing that, and they're going to be increasing the minimum wage until 2029, or at least reviewing for an increase in minimum wage. So if the restaurant industry, the fast food industry, has enabled a council to be established, what does it mean for other industries? Can they do the same for your industry? And this is kind of works as a union. It's like a union protection for our workers. So that's the concerning part for employers. With this assembly bill, who's covered? It's all limited service restaurants, so truly fast food that's part of a chains with over 60 restaurants nationally. Very limited service, so not your big restaurants. Provides food and beverage for immediate consumption on or off the premises. So patrons generally order or select pay, like, you're going up to the counter and ordering. Very limited table service. So exceptions are some bakeries and some grocery stores that maybe have a deli in their place. Those would be exceptions. If you're an establishment, you're unsure whether you qualify, you're eligible for this, please consult with your legal counsel. It's created a lot of open questions that haven't been answered yet, and hopefully this just passed this month, so we're hoping to get some clarity on what are the job duties primarily engaged means. It also creates this question of, are covered exempt employees? If you have a salaried employee working in this industry, are they now going to have to make at least $83,200, which is very high to be a manager at McDonald's? And what this means is they'll probably, if this passes and they clarify that, yeah, it's not double the state minimum wage, we're actually going to make it double the minimum wage under Assembly Bill 1228, which is 83,000. And so employers are probably going to make their managers hourly at that point. So for restaurants that operate within a different industry, if you have like a Starbucks inside a Target or something inside of a gas station, we're not sure if this is going to apply to them. So again, see your counsel for that. And again, this is something unprecedented when we have this council that's setting these rules. Along the same lines is Senate Bill 476, which is the food handlers card. So it used to be we can hire you and say, you're hired at Jersey Mike's and we need you to get a food handlers card because that's a requirement to work here. And oh, you have one already? Great, start using it. You can start them working there. But now you used to be able to say, if you don't have one, we're not going to hire you. You have to go get one. Can't do that anymore. California requires the restaurant owner, the business, to provide that service, that training, and that food handlers if they want them to work there. So you're responsible for all associated costs in the event that they don't have one. So the cost of training, the test, if they have to go take the test, you have to allow them time away from work to go and drive there, and mileage, and pay for them to take the test, all that, if they're an hourly employee. And again, you can't say, I won't hire you unless you have this. So make sure, again, your line managers, they are aware of this, that you update your policies, your hiring and onboarding, so that everybody's aware of this new law if it's something that applies to you. Again, making other industries nervous about, why are we now paying for something that they can take to another job? It used to be that was the argument. They're taking the food handlers card, but then they can quit Jersey Mike's and go work at Starbucks the next day and use that same food handlers card. And so it creates kind of this trouble, this concern for employers that, what are we going to be tasked if it's in a different industry? Do we have to pay for your continuing education or certification? This Senate Bill 525, we almost took it out. We left it in, but it is on hold. This creates 5 different schedules of minimum wage for our covered healthcare employees. So similar to the fast food, we're paying $20 an hour. This would be certain minimum wage for healthcare workers that range from 18 to 23 an hour. This was set, this had passed. It has passed, and it's set to take effect June 1st. But as of about a week or two ago, the governor has placed it on hold after reviewing the budget and seeing that we can't reach a budget, that this has been placed on hold. So if this is not going to apply to dentist office, and there's a lot of exceptions here, so make sure you know that if you're in that industry or in similar industries, consult with counsel, look at the Senate bill, to see if you're an exempt from this. And if you are not exempt, know that it's been placed on hold. So we reached the end of our training. We're going to just do a couple honorable mentions, things that are still out there. The COVID-19 right to recall is a Senate bill. This is for the hospitality sector. This it was supposed to expire. It moves the expiration date for the right of recall rights to December 31st, 2025, because that right of recall was going to expire. So Senate Bill 723 expanded that, and we have a new expiration date. And that's for the hospitality industry to, if you had laid off employees due to COVID, you're now recalling them because business is up, and now you're asking them to return to work. You have an obligation to go to those people you laid off and offer the job to them. Again, hospitality industry only. So this Senate bill expands that expiration date. And then the other one is the indoor heat illness standard, which is something that is going to pass, from what we're hearing, very soon this year. Maybe in the spring or by summer, we'll have an indoor heat illness standard for employers. So again, stay tuned with CEA. So we will alert members and our employers when this happens. And this is very similar to the outdoor heat illness standard, where you have to give extra breaks, water breaks, provide some cooling areas, a time for employees to cool when the temperature reaches a certain degrees. We have that already for outdoor employees, and now we're going to have it for indoor. So if you have warehouses, or if you have areas where it gets very hot and it reaches a certain temperature, and I believe it's going to be 82 degrees, then you have to have some sort of plan, some sort of policy. Again, we may get a template or not, and then you need to know the standards. What is it that we have to comply with if we reach that area indoors? So that is all we have for the labor law update today. Eli, I don't know if there's any outstanding questions or anything else you'd like to add before I give the training codes for anyone who's doing continuing education.
No outstanding questions. I did have somebody ask about membership. I know there was a slide coming up for the training code, so I'll let you carry on.
Yeah, okay, great. So these are the training codes. If you're here for continuing education, HRCI is 654171. SHRM is 24-6TTSY. 24-6TTSY. And yeah, if you are interested in membership, we have things on a monthly basis for 109, and then we have annual ones. And depending on the plan that you get a little bit more. You get membership hours where you have HR advisors helping you with some of your tasks. You get handbooks. We offer handbook templates a la carte if you don't want to join, but you also get them as part of your membership depending on the plan that you get. So definitely check us out at employers.org and see what the different options are. If we can provide a little bit more support than the hotline offers, please let us know. Your hotline calls are limited to 15 minutes, but usually we can get you going after within that 15 minutes. All right, and Anna, I think I will throw it back to you, and I think she just put those codes up in the chat as well. Thank you, everyone.
I did. I put a few things in the chat. So thank you, Eli. Thank you, Astrid, for your wealth of knowledge and answering questions today. I know that's always the added benefit of coming to these webinars is getting your questions answered live, right? So I did put the codes in the chat for continuing education credits. I put a link to the next webinar coming up. It's Communicate Like a Leader. This is a really good one on February 20th. Again, free to you all through Ventura County. And then lastly, as you'll see on the screen right now, we have a QR code. I also dropped a hyperlink into the chat to share your feedback. This is where we really take what you share with us to heart, and we continue to develop our resources. We share this information with Ventura so that we can collectively serve you, right? So we hope that you'll take the 2 minutes to complete the 5 questions. And again, this is the screen for their hotline, and we want to thank Colleen, Cynthia, and your entire team for sponsoring today. And thank you all for joining us live. And we hope to see you on February 20th. Thank you all.